So when we discuss custody in a New York divorce, there's really two general categories we're looking at. We're looking at legal custody, which is the right to make the major decisions in your children's lives and to be informed about their lives. And the second component of that is physical custody. Physical custody is where they're going to live primarily, and how an access schedule will be decided, agreed upon. If your matter is litigated and you have young children and you can't resolve things between you and your spouse, a court is going to resolve custody for you. And they're going to do it. The guiding principle for the court is what's in your children's best interest. That's a really wide standard, and it's a subjective standard, quite frankly. When we try custody cases, unlike in other areas of law, the scope is quite wide. We'll be asking you about your child's upbringing from very early on to whatever age they're going to be. We're going to delve into what their personal life looks like, their social life, their education. We're going to want to know who meets with the teachers, who meets with the doctors. It's really limitless, and it's our job to pick out what is the most important information, what will make the most compelling argument to protect your position and to advocate your position with the court. There are times when it is necessary to go back to court. However, if the two of you agree, you're not bound by that agreement. It is a court order. It is something that you are required to obey. However, there are many times that people come to us, they sign that agreement and they put it in the drawer and they never look at it again. And if you and your spouse are cooperating, then there is no need to go back to court. And quite frankly, it's something that when necessary, you need to do it. But you do want to avoid it because you may be heading down yet another custody battle. These are called post-judgment custody cases, and they can be exceedingly expensive and go on for a very long time. It's something we do when necessary, and when it can be avoided, we do everything we can to help you avoid it. On occasion, people come to us, their case has been resolved for whatever length of time, and they want to relocate. They want to leave New York State, they want to leave Long Island, and they're asking, can I just go ahead and do that? Your agreement may restrict your ability to relocate. It's very common in agreements that will have what's known as a relocation clause, and it may say that you can relocate within Nassau County or relocate within Suffolk County, but not beyond the border. Or it may say you can move as far as 15 miles from where you currently live. If that's the case, we would urge you to respect that and not move without your spouse's written permission. And it should be something that you consult with an attorney on, even if you have an email where they say it's fine if you leave. I've seen people get dragged back into court and go through very ugly and expensive custody litigation battles. If your spouse does not agree, it is something that a court will hear. You need a really compelling reason, and they're going to look at what the ramifications are on your child with respect to their relationship with their other parent going forward. And if it's going to be negatively impacted, that's going to be a huge hurdle for you to get past. There are times that people do successfully win relocation cases. It's not something to be taken lightly. It's certainly not something to do without consulting an attorney. And that's something that we're very skilled at. And we're more than happy to discuss it with you if this is something that you're contemplating or if it's something that your former spouse has done or is about to do. If you have any questions whatsoever about how custody works in a divorce, how access schedules are determined, or post-divorce, if you're contemplating a change in that, please reach out to us. This is what we do, and we're happy to help here at Joseph Law Group PC.